Panginoon manunod ko. Uy, gusto mo
Ako
ba?
ka dyan dito.
Sige na, pwede na.
Kasi naka-off ikaw. Di ba, nagbiyang mag-iwi?
Sige na.
Ikaw ang sote?
Ay, nalala ko na. Prayer na lang siya. So, we'll start a webinar
Sige na.
with prayer.
Ayun na. Ayun na, di ha? Sige ka. Ay, mag-iwi ko. Sige.
Sige, go.
Ano?
So, good evening. We'll start our webinar with a prayer followed by the national anthem.
Wag na rin matulog.
Walang ako.
Yun, nagbalik. Tagay ako din ko sure.
Itsulat.
Ano wag na tayo?
Dear Lord, we praise and worship you today. You are exalted in our midst. We ask for forgiveness for every sin we have done. Have mercy on us, our Father. As we start our program today, let your guidance and protection be upon us. Send your Spirit to us and give us wisdom. We thank you for all the blessings we have received. We also thank you for the lives of the people in this place. Be glorified in everything we do. In your name pray. Amen.
Mga kababayan, ang pambansang awit ng Pilipinas.
Good evening, future accountants. Welcome to the webinar series initiated by the senior students of the Accountancy Department of St. Joseph College, Maasin City. This is Paminaw, Create Act, Intellectual Property Act. So hi guys, I hope that everybody is doing okay despite the situation that we are in. Okay na mo diha? So, maminaw lang ta and later naatay mga game or natay game then load ang prize. So, we'll start. At this point, I will now introduce to you our speakers. First speaker is Miss Arcely Espinosa. She will discuss about Create Act, then the law on the patent as part of the Intellectual Property Act. Next speaker is yours truly, and my topic is about the law on trademarks, service marks, and trade names. Followed by Miss Justin Shin Guy, who will discuss about the law on copyright. Then Miss Milche Guhoko will continue discussing the law on copyright. So, help me welcome our first speaker, Miss Arcely Espinosa.
Good evening, everyone. I am Arcely Espinosa, the first speaker for tonight. So, let me share my screen. Relax lang.
Kaya nagpipiti sa abos.
Hindi man makita. Wait. Nakita na.
Ayun. Share.
So again, good evening. I am introducing to you Create Act. So what is Create Act? Create Act is the Republic Act number 11534, or otherwise known as the Corporate Recovery and Tax Incentives for Enterprises, which was created by the Philippine Congress in response to the COVID-19 pandemic as a fiscal relief to domestic and foreign corporations doing business in the Philippines.
Wait lang.
The Corporate Recovery and Tax Incentives for Enterprises is the largest fiscal stimulus for businesses in our recent history. It is estimated to provide private enterprises more than 1 trillion pesos worth of tax relief over the next 10 years. So what is the purpose of this Create Act? This is the comprehensive tax reform program that reduces corporate income tax rates. And so, who are affected by this Create law? It is applicable to all non-VAT registered taxpayers with annual gross sales of 3 million pesos and below, effective on July 1, 2020 up to June 30, 2023. So these Create Acts also provides other forms of tax relief which are part of a package of economic recovery measures implemented by the government to address the varying needs and concerns of the business sector brought about by the ongoing COVID-19 pandemic. CREATE Act also provides for a generous and flexible tax incentive system that is performance-based, time-bound, targeted, and transparent. These principles have been unanimously recognized by stakeholders during hearings and consultations. So during these times of pandemic, some businesses is nag-close, diba? Then due to health protocols po, ang ubang businesses is limited ra up to 50%. So this CREATE Act cuts corporate income tax rate from 30% nga daan gikat siya to 25% to help businesses nga maka-recover pod sa ilang nga loss. Then let's proceed to the Intellectual Property Code of the Philippines. This IP Code of the Philippines or the Republic Act number 8293 as amended up to RA 10372 monig sa una. So it is an act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing for its powers and functions, and for other purposes. So this act shall be known as the Intellectual Property Code of the Philippines. The state recognizes that an effective intellectual and industrial property system is vital to the development of domestic and creative activity, facilitates transfer of technology, attracts foreign investments, and ensure market success for our products. This Intellectual Property Code of the Philippines, it shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to people for such periods as provided in the Act. So kaning Intellectual Property Code of the Philippines, money ang nagprotect sa mga nag-invent, sa mga naka-discover og mga new invention para ilarang masolo ang ilang reward ibali as an inventor. So the use of this intellectual property bears a social function. To this end, the state shall promote the diffusion of knowledge and information for the promotion of national development and progress and the common good. So it is also the policy of the state to streamline and administrative procedures of registering patents, trademarks, and copyright to liberalize the registration of the transfer of technology and to enhance the enforcement of the intellectual property rights in the Philippines. So what are the intellectual properties nga makover sa kanang protection? These are copyright and related rights, trademarks and service marks, geographic indications, industrial designs, patents, layout designs of integrated circuits, and protection of undisclosed information. So let's start with the patent. So what is a patent? A patent is a monopoly granted only for specific purposes and objectives. Thus, its procedures must be complied with to attain its social objective. Any request for leniency in its procedures should be taken in this context. Patents are the exclusive right granted by the government to an inventor to manufacture, use, or sell an invention for a certain number of years. An invention or process protected by this right. So, og na kay invention nga ikaw mismo naghimo, pwede na nimo siya protektahan nga imo ra for a certain period of years para ikaw ray mag-enjoy sa reward ingana. And then, the head of the Intellectual Property Office is called the Director General. So this Intellectual Property Code, which means the Republic Act number 8293 or otherwise known as the Intellectual Property Code of the Philippines. So, ang own publication ani niya is ang Gazette. Gazette na siya guys, or kung sa internet na siya makita mo ng e-Gazette. Then, what are now the patentable inventions? So, unsa tong mga pwede nga mahimong kuanan og patent? Any technical solution of a problem in any field of human activity, take note of this, which is new, involves an inventive step, and is industrially applicable. Dapat na ana silang tulo. Kay mao na important sila nga mga elements for a patent na magrantan siya og kanang reward. It may be or may relate to, it can be a product or process or an improvement of any foregoing. So, the patent law has threefold purpose. Nasidjay tulo ka purpose. First, the patent law seeks to foster and reward invention. So, ang kaning patent, kung kinsa tong rewardan, unsay nga sa rewardan kibali is mao mismo ang inventor. So, it promotes disclosure of inventions to stimulate further innovation and to permit the public to practice the invention once the patent expires. So, there's a certain period of time nga ma-enjoy sa inventor ang iyang nga patent. So, after ingana nga years, certain years, pwede na niya ma-expose to public, ma-disclose na sa public for the public to enjoy na ingato nga invention. Third is the stringent requirements for patent protection seek to ensure that ideas in the public domain remain there for the free use of the public. So, matong gingon nga after ihisgutan na pila ka years later, then free use of the public na siya. In order for the patent nga ma-grantan siya og kanang patent, dapat diba new? So, these are the elements of novelty. Novelty or new, mara na siya. If a device or process has been known or used by others prior to its invention or discovery by the applicant, an application for a patent therefore should be denied. Of course, kung mahibaw-an nga nanadilain nakahimuing ana, an application therefore should be denied. And if the application has been granted, the court, in a judicial proceeding in which the validity of the patent is drawn in question, it will hold it void and ineffective. So, kung mahibaw-an po nga dili ra ikaw ang kinaunhan hing-invent ingana nga butanga, then it will hold void and ineffective. Aysa. Mo check sa ko og nadunggan ba ninyo? Guys, mangayo kong feedback og nakadungog ba mo or nakakita ba mo sa screen?
Yes. Nakita.
Okay ra?
Yes.
Okay, thank you. Proceed ta. Sakay daghang nanood. Proceed to, so what are the patentable inventions? Sa may mga patentable inventions? Statutory classes of patentable inventions. A patentable invention may relate to, it can be a product such as machine, a device, an article of manufacture, or a composition of matter, or a microorganism. It can also be a process, such as method of use, method of manufacturing. It can be a non-biological process, or a microbiological process. It can also be a computer-related inventions, and an improvement of any of the foregoing. So, manasadya ang mga patentable inventions. Kung naatay patentable inventions, naaputay non-patentable inventions. These are discoveries, scientific theories, and mathematical methods. And in the case of drugs and medicines, the mere discovery of a new substance or new property of a known substance. Or schemes, rules, and methods of performing mental acts, playing games or doing business, and programs for computers. Methods of treatment of the human or animal body. So, nana sa reason nga nung dili na sa patentable. Kay, naanay naka-invent na nidaan from prior nga mga scientist. Labi nag-exist na si John, gi-innovate na laman. So, maon di si John pwede nga mapatent. Also, di pa di ay plant varieties or animal breeds or essentially biological process for the production of plants and animals. Then, aesthetic creations and anything which is contrary to public order or morality. Ang kaniyang last, di ba, new, dapat ang patent has inventive step and is industrially applicable. So, if contrary to public order or morality si Ja, which can cause harm sa people around you, then dili na si Ja mahimo nga patentable. Then, mani nga, novelty is an invention shall be considered new if it forms of a prior art. When we say prior art, wa pay naka-design, naka-invent, nga past nga mga art kibali. So, money prior art, everything which has made available to the public anywhere in the world before the filing date or the priority date of the application claiming the invention. Wa pay naka-file o application ingani nga certain nga invention. So, kinsay tag-ija sa invention? Ang inventor. Inventor is any person who, at the filing date of application, had the right to the patent. So, a patent nga makonsider nga patentable si Ja kung naa si Ja inventive step. An inventive step is an invention involves inventive step if, having regard to a prior art, it is not obvious to a person skilled in art at the time of the filing date or priority date of the application claiming the invention. So, kung naa kay na-invent makibali, so dapat mag-file makaingana, then sa file nimo i-narrate nimo giunsa na nimo si just step by step ang pag-invent. So, in the case of drugs and medicines, there is no inventive step if the invention results from mere discovery of new form or new property of a known substance. Kung new discovery ra sa mga substance nga na form na daan, so dili siya pwede. And mo ni ang last nga elements nga para patentable siya. An invention that can be produced and used in any industry shall be industrially applicable. So if beneficial siya sa tao, everyday nga use, then it can be patentable. So who have the right to a patent? It can be the inventor himself, his heirs or assigns, and when two or more persons have jointly made an invention, then the right to a patent shall belong to them jointly. And who may be named in the application as an applicant? The application may be filed by the actual inventor, katong mismong nag-invent sa invention, or in the name of his heirs or legal representatives or assigns. So, who has the right to a patent? Natay first to file rule. If two or more persons have made the invention separately and independently of each other, the right to a patent shall belong to the person who filed an application for such invention. So, natay duha ka mga inventor, mga bright nga mga inventor. So, kanang, if pareha sila made in a usa ka invention, pareha sila made, ang right to a patent is katong usa nga hing file of application. But when there are two or more persons applications are filed for the same invention to the applicant who has the earliest filing date or the earliest priority date. So, kung pareha silang duha nag-file of application, kinsa man ang na-right sa patent, kadtong kinaunhan nga ni-file the earliest filing date or the earliest priority date. Maotoy na ay right to a patent. Ang kinaunhan, first to file rule. Maagian na ninyo pohon inig second sem kay murag inig kuanin ninyo. No, second sem. Oh, second sem. Then, the inventions created pursuant to a commission. So, kung may tag pursuant to a commission is na ay nagpahimo lain. Mao niya kinahanglan, the person who commissions the work shall own the patent. Kung kinsa tong nagpahimo, ning bayad man si Jackie Bali, di ba? Kung kinsa tong nagpahimo, diyan na invent noon hinuon to nga invention, so kadto ang nagpahimo, maoy mo tag-ija sa patent. Unless na sila contract ipermahan, mao na anha mautro. And in any case, the employee made the invention in the course of his employment contract, the patent shall belong to. Ang meaning ingani, tahay na ako sa office, unja, employee ra ko kay ning nagtrabaho ra ko sa akong employer kibali. And if na ako'y na-invent nga dili part sa akong regular duties, tahay auditor ko. Ang auditor sige kuan sa mga financial statements, review kibali, di ba? And if naatahay ko'y nahimo nga ballpen nga once nga musuwat ko ingato nga ballpen, automatic nga mutatak nga to sa screen sa akong laptop. Kana ba ingana kanang mga wild nga mga invention nga mahimo naho, which is not part of the regular duties naho, ang invention, ang patent shall belong to naho kibali, the employee. If the inventive activity is not part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. So ako'y manag-ija, kay dili man usual part sa akong routine. Pero, ang mutag-ija sa patent is the employer kung if the invention is the result of performance of his regular assigned duties unless there is an agreement. So ako tahay nagtrabaho ko sa pabrika, employee ko sa pabrika sa ballpen. Then part na sa regular duties na ako nga of course himog ballpen. So sa ingan nga time na invent na ho to nga mismo nga ballpen nga kuyawon. So ang mag-ija ato akatong akong employer. Unless, manapod ni, there is an agreement, expressed or implied to the contrary. So, kung may agreement na mo between the employer and employee, employer relationship, so, maotro na pod ni, kabaliktaran. Then, mao ni ang kibali summary. So, kung kinsay has the right to a patent. So, when two or more persons have jointly made an invention, kung silang duha, nag-made sa usa ka invention, connected silang duha, then the right to a patent shall belong to them jointly. Silang duha man nag-ija sa patent. And when two or more persons have made the invention separately, buwag sila, and independently of each other, so, ang kinaunhan ingato, ang the right to a patent shall belong to the person who filed an application. So, nilang duha, same invention, kung kinsay ni file sa application, maoy has the right to a patent. And when two or more applications are filed for the same invention, silang duha ng file. Ang tubag ani, ang right to a patent is katong applicant nga who has the earliest filing date or the earliest priority date. Kung inventions created pursuant to a commission, mao na to ang nagpahimo, nagpa-commission, maoy man nag-ija sa patent. Unless na sila contract, then the employment, then there is last is the employee made the invention in the course of his employment contract. Kung employee-employer relationship, maning sa employee, if not part of his regular duties. But sa employer, if the result of the performance of his regularly assigned duties. Unless, mautro na rin silang duha if na ay contract. So, let's proceed to the patent application. Kinsa may mo file, pwede mo file sa patent. Ang pwede mo file sa patent is any person. Bisan kinsa, natural or juridical, may apply for a patent. If the application is not the inventor, the office shall require him to submit a proof of his authority to apply for the patent. Bisan kinsa, basta naka-invent ka, o para nimo new na siya, ug para nimo na ay inventive steps siya, ug para nimo industrially applicable, you can file a patent. Accept. Ay, sakay. Wa man. Asaram itong manod. Continue. So, the definition of a juridical person. Kaya ba siguro may nga ni? Unsay juridical person? A juridical person is a body of persons. It can be a corporation, it can be a partnership, or any legal entity that is recognized by law, which grants a juridical personality separate and distinct from that of the shareholder, partner, or member. So, kani siya, nabuo ra ni siyang juridical person, kay gi-recognize siya sa law. Meaning, ang law nay kanang nibuo nila as a person, pero separate siya sa mismo nga tag-ija, sa shareholder, sa partner, o sa member. Then, unsaon taman, when the applicant dies, becomes insane or nabuang or incapacitated. So, in this case, the applicant dies, becomes insane or incapacitated, the legally appointed administrator, legally appointed ha, kanang agi jug process pud ba, executor, guardian, conservator, or representative of the applicant may sign the application papers and other documents. So, si Jay magpadajod. He may also apply for and obtain the patent in the name of the applicant, his heirs, or assignee. Then, the assigned invention and patents. In case the whole interest in the invention is assigned, the application may be filed by or in the name of the assignee who may file the application. In case the assignee is a juridical person, so any person thereof may sign the application in behalf of the said person. So, ang kaniya siya is kung juridical person man kani, any officer in behalf sa kadto nga tibuan nga juridical person. So, pwede siya company, di ba, or a partnership. So, any representative. So, muna ni application. The application shall be usa sa Filipino or Tagalog o one sa English and shall be contain the following. Monisod. Dapat na request for the grant of a patent na ay description sa invention from kinaunhan hangtod na human. Mao na meaning. Then, kung di pa jud kaadyo murag blurry pa jud, kung kinahanglan pa jud drawing aron masabtan ang tibuok invention, then you must draw your invention. One or more claims and an abstract. Kung unsa na siya tanan, unsay use, unsa tanan. More bag abstract sa kuan. Sa what are the research all about. Tingnan na, di ba? So, no patent may be granted unless the application identifies the inventor. If the applicant is not the inventor, the office may require him to submit said authority. So, kung dili, why patent nga mag-grant kung wagi pahibaw kinsay nag-invent mismo nga ng invention. And kung dili ang inventor mismo ang nag-file sa application sa patent, then ang office maoy mo require ni dyan nga mag-submit si jag authority na si jay kanang authorize mismo sa inventor nga si ang mo apply for a patent. Then the appointment of agent or representative, an applicant who is not a resident of the Philippines, mo gihapon ni i-appoint ra gihapon ni dyan nga resident agent sa Pilipinas. Then ang the request shall contain karon pa guys, wala may nakitang screen slide. Ay, wala na. Okay. Oh, na mag-monitor. Kana. Kana, guys. Sa.
Yes, makita na. Thank
Oh,
you.
makita na. Ah, sige. Oh, sige. Nana? Mayor. Nana? Nana, guys? Okay. Asan ako? The request. So, the request shall contain a petition for the grant of the patent, the name and other data of the applicant, the inventor and the agent, and the title of the innovation. So, dapat kumpleto ni Sija ang application. Na name and other data, dapat kumpleto. And also the inventor. O sa title, sa imong gi-invent. Dapat na ingan. Then, maoni, ang first is the petition for the grant of patent. Manisod sa gihapon sa application, dugang. Dapat na ang applicant's name, naa ang complete address. Then, dapat na i-title imong invention o mismong inventor's name. Kay di ba pwede lahi ang mo file for the application. So, dapat na inventor's name. And if with claim for convention priority, it shall contain the file number, country of origin, the date of filing in the said country where the application was first filed. Kung naman gani ka na bang nanay una lain nakasuwat, so dapat ikuan to, ilocate kung asa man ganito siya naka-file. And then last is the signature of the applicant or resident of the agent or representative. So, a patent is granted to provide rights, manhanggingon ganina, and protection to the investor after an invention is disclosed to the public. It also seeks to restrain and prevent unauthorized person from unjustly profiting from a protected invention. Once magranta na kag patent, protected na imong mismo nga invention. Kay ikaw rin na ikaw galingong rights and protection gikan sa government. So, mao ni ag procedure. Where na ko? Procedure for the grant of patent. First is the filing of the application. So, mo fill up ka sa application form. I-identify nimo imong kagalingon and the description sa imong nga invention dapat 1 in Filipino or Tagalog, 1 in English. So, ug laking gana na siya ang patent pwede ma-withdraw. Oh. Sunod is the according a filing date. Kano sa maning filing date? It should be the date when all the elements are received. Kung tanan nga gi-require sa filing sa application, na-receive na tanan, kompleto, mao ni ang mismong date nga giingon sa first to file rule. Oh. Next is the formality examination. There is a formality examination na si Jai required nga fee. Within 1 month, dapat bayaran na nimo. Then, proof of authority kung di man gani ikaw ang mismong inventor. And deed of assignment kung gi-assign na po nimo. Then, next is the classification and search. There is a classification and search. This is to determine whether there were prior art. So, kulingon na po na nila kung naamang gani naka-invent na ingana or na nakilaing nakahimuan na before ka-file. So, daghan pa ng process, taas pa na. Publication of patent application. So, it shall contain bibliographic data. It is confidential without the consent of the applicant. So, diri nga time, publication of patent applications, request for kanang substantive examination. So, sige rin po ni examine na niya kung para mahibawan isa nga pasip sa ganun karon pa sudag uban. So, after sa long kanang examination, kung kuan man gani, new man ganito, pasar sa dya sa naas dya inventive step, pasar sa dya nga industrially applicable sa dya, then you magranta na ka og patent. After ana is publication of the patent. Asa ganito i-publish adto sa Gazette. Gazette ang own publication sa Intellectual Property Code of the Philippines. And then last is isyuhan na ka og certification sa patent. Then, muna ni grant of a patent, pila ka years. Term of patent shall be 20 years from the filing date of the application. So, ikaw ra mismo ana, protected ka nga, ikaw ra mismo dapat maka-enjoy nga ng imong invention. And after ana sa 20 years, ma-expire naman na. Then after inga na, pwede na ang lain, for the public use na siya. Kaya human naman ang 20 years nga gihatag sa government nimo. What na pod? Hindi na makita ang screen. Napa? Oh, sige. Star. So, naganta na ka. Pwede makancel ang patent, dili? Pwede. Ako rin tubag. So, the cancellation of patents. Kinsa ang pwede mo cancel? Kanto yung mga interesado, no? So, the cancellation of patents, any interested person may, upon payment of the required fee, petition to cancel the patent or any claim thereof or parts of the claim on any of the following grounds. So, mano yung mga rason tahay sa mo cancel sa imong nga patent. Interesado nga tao nga mo cancel sa imong patent. Pwede na ni dyan mahimong reason. 1. That what is claimed as the invention is not new or patentable. So, ingon tong nga nang hing pa-cancel sa imong patent nga dili kuno to new. 2. That the patent does not disclose the invention in a manner sufficiently clear and complete for it to be carried out by any person skilled in the art. So, wa kuno nimo taro nga dito og butang sa imong application nga kanang tanan nga mga process paghimo nimo ingato nga invention. Then, that the patent is contrary to public order or morality. Or mo ni giingon nga kanang it can cause harm people sa kaning imong invention. And where the grounds or cancellation relate to the claims or parts of the claim, cancellation may be affected to such extent only. So, the requirement of the petition. The petition for cancellation shall be in writing. So, mao gihapon sa application. Digba mag-file ka og application for patent in writing. So, ang requirement for petition pod is in writing. Verified by the petitioner or by any person in his behalf who knows the facts, specify grounds upon which it is based, include a statement of the facts to be relied upon, and filed with the office. Cancellation of the patent. If the committee finds that a case for a cancellation has been proved, it shall order the patent or any specified claims to claim or claims thereof. So, kaning cancellation of patent, kung ang pag-file sa application is taas kaadjong paagi, then ang pag-cancel po sa patent, taas po nga paagi. Ang committee pa mo find kung unsa man gani something wrong ingana nga patent. Then, remedies of a person with a right to a patent. So, if a person referred to in Section 29 other than the applicant is declared by the final court or decision as having the right to patent, such person may, within 3 months after the decision has become final. So, kung dili man gani ikaw ang mismong, kung katong file, dili man gani si ang original nga inventor, so, pwede na nimo si Jack prosecute the application as his own application in the place of the applicant. So, ikaw mismo mo file. Then, file a new patent application in respect of the same invention. Kibali, infringe kibali ni Jack imong buhat ba? So, ikaw mo file ingato nga same invention and request ka nga ag application ingatong usa ma-refuse o ma-denied. And of course, seek cancellation of the patent if one has already been issued. Kung na-issuehan na tong patent, mangita na po mo file na po cancellation ingatong nga patent. So, money remedies of a true and actual inventor. Katutahing file is dili mismo ang inventor ingatong nga invention. So if a person who was deprived of the patent without his consent, meaning lagi through fraud, which is declared by the final court order or decision to be true an actual inventor, the court shall order for his substitution as patentee, or at the option of the true inventor, cancel the patent and award the actual and other damages. Kung mahibawan gani nga dili to siya mismo ang original nga nag-invent kay kanang infringe through fraud, ija tong gi-apply tong application. So dapat i-cancel to nga patent sa IP office, Intellectual Property Office, and then rewardan, taga-award ang actual an inventor og pabayaron og damages ang kadtong nang infringe sa invention. Then mao ni ang summary kibali, when two or more persons have made the invention separately and independently of each other, then a person who was deprived of the patent without his consent or through fraud, which is declared by the final court order or decision to, so diri sa section 68 is na ay fraud nga nahitabo, di ba? So the remedies of a person with the right to a patent. Where na me? Publication of court order. The court shall furnish the office a copy of the order or decision. So, kung fraud magani to, dapat illegal proceedings pa man jud na. So, i-cancel ka jud to. And then, rights of patentees and infringement of patents. So, rights conferred by a patent. A patent shall confer its owner the following exclusive rights. Kung subject matter magani sa patent is a product, then as the right to restrain, to prohibit and prevent any unauthorized person from or an entity from making, using, or offering for sale, selling, or importing the product. So kung product magani si Jana, si J right mo stop, na si J right mo dili sa uban kay ija raman to. And then where the subject matter of a patent is a process, then na po sa ikaw galingong right, ijarang exclusive right to restrain, prevent sa uban para di makahimuingan nga process, or prohibit any unauthorized person or entity from using the process. So, kanang mao ni si ang all about sa patent. And then, we call Mr. Ian Formento to continue and discuss about voluntary licensing.
So guys, to continue, so voluntary licensing, section 85, voluntary license contract. To encourage the transfer and dissemination of technology, prevent or control practices and conditions that may in particular cases constitute an abuse of intellectual property rights having an adverse effect on competition and trade. So in voluntary licensing, this refers to the practice of IP holders or the intellectual property holders voluntarily granting license to their patents to other IP. So, in voluntary license, it can take in many forms, and the government has or the public has the right to have the right to have that patent. While, okay, what is technology transfer arrangement? So, this shall means contracts or agreements involving the transfer of systematic knowledge for the manufacture of a product. So, technology transfer, in short, this is the movement of your products from one organization to another organization. This also a transfer that can take place between universities or businesses and the governments. Just like the patented products just like research papers. So pwede na siya magamit sa eskwelahan. Okay, it's for educational purposes man. And compulsory licensing is when government allows someone else to produce a patented product or process without the consent of the patent owner. So, naay right ang government nga mukuha ato nga patented product bisan dili sa tag-ija sa government. It's because of kanang naay kailangan sa mga kanang national emergency mga kanang circumstances. So in section 90 subsection 93.1 mo tong giingon national emergency or other circumstances of extreme urgency. Then next, with the public interest in particular sa national security, kung kailangan na jud sa atong country, so compulsory na sa nutrition or sa health and the development of our vital sectors of the national economy, so pwede makuha ang katong nga patent. Then a juridical or administrative body has determined that the manner of exploitation by the owner of the patent or his license is anti-competitive. Next, in case of a public non-commercial use of patent by the patentee without satisfactory reason, so why personal nga kwan, only for the government. Then, if the patented invention is not being worked in the Philippines on a commercial scale, although capable of being worked without satisfactory reasons, so same na sila dito sa subsection 93.4, provided that the importation of patented articles shall constitute working or using the patent. Next, where the demand or patented drugs and medicines is not being met to an adequate extent and on reasonable terms is determined by the Secretary of the Department of Health. Okay, just like sa mga tambal, labi na og naay kanang giingon diri sa atong health, so the government has the right nga mogamit sa katong product. Then, let's now proceed to the law on trademarks, service marks, and trade names. So, what is trademark? So, in the Supreme Court defined a trademark as any distinctive word, name, symbol, emblem, sign, or device, or any combination thereof, adapted and used by manufacturer or merchant on his goods to identify and distinguish them from those manufactured, sold, or dealt by others. So just like McDonald's, Jollibee, airlines, Philippine Airlines, mga sapatos, Adidas, so mo na yung mga trademarks. In Republic Act 8293 or the Intellectual Property Code of the Philippines, in its simplest definition, a trademark is any visible sign capable of distinguishing goods. So, kung ikaw na kay goods, na kay services or product, para mahibawan sa largo sa uban, so dapat naadjud kay kanang symbol or a name or a sign nga mag-distinguish sa imong product or service or goods sa uban. That's just like sa mga bags natay Chanel, mga ana. So mo nang dapat na akay kanang imong symbol or trademark. So there are three distinctive functions. First is they indicate origin or ownership of the articles to which they are attached. So this is the personal or the possession. Aron may bawaan nga ang kana nga products is ang tag-ija is Goldilocks, ang tag-ija is Jollibee. So that is the ownership. Then they guarantee that those articles come up to a certain standard or quality. So sa ngan palaman or sa ngan palaman makahibaw na ka nga ang kini nga brand is kanang naay quality ug naay standard. Third is they advertise the articles they symbolize. So syempre og sa ang nang trade na kay trademark, so mahibaw-an sa mga tao nga Ari jud sila mapalit kay kanang non-standard, non-equality. Next, functions of trademark. So, first is to point out distinctly the origin or ownership, or mo ingon is the possession or the ownership. Then to secure to him who has been instrumental in bringing into the market a superior article or of merchandise the fruit of his industry and skill. So, to secure na kay right and security nga imo ng trademark or sa kana nga manufacturer ang trademark. Then to assure the public that they are procuring the genuine article. So na kay assurance ang kanang katong nga manufacturer na assurance nga ning procure sila og na standard o na quality nga product. Then to protect the manufacturer against substitution and sale of inferior and different article as his product. So na protection nga di why bisan kinsang makasundog sa inyong symbol or kana nga mark. Then what is mark? So mark means any visible sign capable of distinguishing the goods or services of an enterprise and shall include a stamped or marked container of goods. Then trade name means the name or designation identifying or distinguishing an enterprise. So in short, mark is a symbol and trade name or is a name or designation sa kanang product. So section 1, 2, 3, registrability. A mark cannot be registered if it, so dili ma-register ang usa ka mark if A, it consists of immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest connection with persons living or dead, institutions, beliefs, or national symbols, or bringing them into contempt or disrepute. So, basically, og immoral jud na, so dili jud na siya acceptable sa public. Next, consists of the flag of arms or other insignia of the Philippines. So, or any political subdivision. So, nagani mga flag sa any country or mga political subdivisions sa or foreign nation, dili na pwede. Then, it consists of name or portrait of signature identifying a particular living individual. So, dili jud pwede except kung naay written consent or naay written or signature sa kadto nga inyong gamiton. Then, D, if it is identical with a registered mark belonging to a different proprietor or a mark with an earlier filing or proprietary date in respect of. So, this same sa patent, so, dili na acceptable ang imong mark if nanay nakauna. Og same goods or services, closely related or service goods or services, and if it nearly resembles such a mark as so likely to deceive or cause confusion. Kung pareha mong product or closely related, bisag closely related na pwede ka mo file ka og complaint if naakay nanay nangahitabuan na sa una. Then kung maka-cause man gusto dya og confusion, maglibog man ang mga tao tungod sa kanang ingana nga mga issues. Next, E, identical or confused, same ra na siya nga maka-result gyapon siya og kanang confusion sa mga tao and kanang makuan na noon mawa na ang kanang product, original product, mawa na noon ang mga buyers tungod kay same mo or identical mo sa nakauna nga product. So dili na madawat, dili na siya pwede nga ma-register sa Intellectual Property Office. Then what is trademark dilution? Trademark dilution is the lessening of the capacity of a famous mark to identify and distinguish goods or services regardless of the presence or absence of 1. Competition between the owner of the famous mark and other parties, or 2. Likelihood of confusion, mistake, or deception. So in other words, it refers to the unauthorized use of the application for a trademark nga maka-cause na siya og kanang mistake sa mga tao, sa public. Then same gyapon if it is identical nga makadamage na pud sa kanang mark nga gi-register, so dili na siya pwede. Then G is likely to mislead the public, particularly as to the nature, quality, characteristics, or geographical origin of the goods or services. So same gyapon kung kanang makamislead sa public, particularly gi-mention na diri ang nature, ang quality niya kung naba sa standard, ang characteristics niya, and its geographical origin. Then consist exclusively of signs that are generic for the goods or services that they seek to identify. So if the signs are generic, so ay sa akin na yung sod, excuse me. So what is generic? The term generic are commonly used as the name or description of a kind of goods, such as light for beer and chocolate fudge for chocolate soda drink. So light for beer, so diba, just like pale pilsen. So if we talk about pale pilsen, it's generic kay pale is a color and pilsen is a kind of beer or light for beer. So generic lang siya, wa man sa niagi og critical nga mga kanang actions. And chocolate fudge, di ba, for chocolate soda drink, so that's generic term and dili na siya pwede ma-register. And descriptive marks nga mo convey siya sa characteristics, functions, qualities, or ingredients of a product to one who has never seen it or does not know it exists. Such as, for example, so for arthritis medication, ang imong trade name is arthritic care, or ang imong mura naman ka og nag-describe or simply describe naman ka, so dili jud na sa pwede given as sa dili sa H consists exclusively of signs that are generic for goods or services that they seek to identify. So consists exclusively of signs or of indications that have become customary or usual to designate the goods or services in everyday language or in bona fide and established trade practice. So kung basic lang sa customary ka nang imong mailhani mo adlaw-adlaw nga kanang generic term or kanang language, so dili na siya pwede ma-register. Then same gihapon, then sa K consists of shapes that may be necessitated by technical factors or by nature of the goods themselves or factors that affect their intrinsic value. So kung kana nga shape kanang nanasay technical factor, dili na sa pwede. So i-test magyapon na sa ato nang discuss later. Consists of color alone, dili gyapon, and is contrary to the public order or morality. Kung dili na sa pwede, dili na sa legal, so just like kanang mga kanang di kaya-aya nga mga pictures or mga symbols, I mean, so dili sa pwede. So there are two tests, the dominancy test and the holistic or totality test. So when we say dominancy test, it focuses on the similarity of the prevalent features of the competing trademarks, which might cause confusion or deception and thus infringement. Given more consideration are the oral and visual impressions. So dominancy test, kung ang pagtanaw pa naman sa public is nanasadya visual and oral similarity sa kanang product nga naka-register na sa IPO, so mga nandili sa pwede. And its holistic test, it talks about the entirety of the marks, including the labels and the packaging, so dili po na sa pwede. So who may apply for a mark? So the applicant may be a natural or a juridical person. So pwede sa og juridical person ha or an entity, pwede po sa og ikaw jud mismo nadto. So in section 124, we have the requirements. So same sa patent shall be in Filipino or in English, then and shall contain the following: a request for registration, then the name and address of the applicants, then the name of the state of which the applicant is a national or where he has domicile sa Napudyo, then where the applicant is a juridical entity, so dapat ang katong nga juridical entity is existing and well organized. So then the appointment of an agent or representative if dili mismo ang applicant nagdomicile diri sa Philippines, pwede ra og na representative. Then the applicant or the registrant shall file a declaration of the A or DAU of the mark with evidence to that effect as prescribed by the regulation within 3 years gikan sa pag-file nimo sa katong application. Otherwise, ma-refuse ang mark and shall be removed from the register by the director. So dapat tumanon jud na. And its duration, a certificate of registration shall remain in force for 10 years, provided that the registrant shall file a declaration of actual use or the DAU and evidence to that effect, or shall show valid reasons based on the existence of obstacles to such use, as prescribed by the regulation within 1 year from the 5th anniversary of the date of the registration of the mark. So kung dili, otherwise the mark shall be removed same sa register by the office. So we have 5 elements of trademark infringements. So first, the trademark being infringed is registered in the Intellectual Property Office kung ang katong trademark gisundog, so that is trademark infringement. The trademark is reproduced kung nag-reproduce ka, counterfeited, copied, or colorably imitated by the infringer, so you will be penalized by of trademark infringement, labi na og mag-reproduce ka og mga products. Then the infringing mark, para na lang kanabitong like mga habagat, so mag-produce ka og mga bags nga dili kadto mga kuanda kanang mga imitate ra, so pwede to na to kanang matagaan og kanang case. The infringing mark is used in connection with the sale, offering for sale, or advertising of any goods or businesses kadto kanang matagaan ka puntos dya og case. Then the use or application of infringing mark is likely to cause confusion kadto kung makalibog na or makahatag na og kasadyupan sa public, then mao gihapon. Then the use or application of infringing mark is without the consent of the trademark owner or the assignee thereof. So syempre kung wa kay kanang consent sa katunga manufacturer or katunga trademark, so nadyo kay case nga trademark infringement. So in section 170, the penalties. So independent of the civil and administrative sanctions imposed by law, a criminal penalty of imprisonment from 2 to 5 years and a fine ranging from 50,000 pesos to 200,000 pesos and shall be imposed on any who is found guilty of committing any of the acts mentioned in section 155, section 168, and subsection 169. And ang sud-ana is mauni sila ang kana nga mga elements of trademark infringement. So that would be all for that topic, and let's now proceed to the law on copyright to be discussed by our speaker, Justin Shin Guy. Thank you.
Off man ako.
Guys. Next. Hello. Hello guys, napa mo? Napa ba ni sila? Hello.
Yes, hello.
Ah.
Hello.
Good evening.
Hello. BA. By the way, I'm Justin Shingay, BSA 4A. So tonight, I'm going to discuss the law on copyright. So, kabantay ba mo mag-post mo sa Facebook nga na ay music? Nja, ma-mute si Ja. Kabantay mo nga na?
Yes.
O, tungod na kay ang Facebook na-feature nga kanang na-feature ang Facebook nga kung di nimo butangan og caption nga kanang no copyright infringement intended or disclaimer inga na ma-mute jud ang imong video nga gi-post nga na ay music inga na kay tungod na sa law on copyright. So what is unsa man jud ang copyright? So copyright is a right over literary works and artistic works which are original intellectual creation in the literary and artistic domain, protected from the moment of creation. So, ang pasabot, ang copyright is given to original creators of literary and artistic works. Kung may nagtitag original, ikaw mismo naghimo. So, once na kay original creation, it is already copyrighted. So, it means it is protected of the law on copyright from the moment of their creation. So, kining copyright na ay automatic protection. Kita ay maghip na kay gibuhat karon, kita ay naghimo kag kanta, na natoy automatic nga copyright. Copyrighted na to si Ja. So, unja kining copyright, no need na ni og registration. So, kini nga law on copyright si bali very special kay di ba simple ra kaadyo nga maghimo ka unja kanang protected na si Ja dajon. So manang lisod pud ni si Ja i-determine whether or not nga there is a violation on the law on copyright. So next is the copyrightable works. So ang mga copyrightable works meaning mga works ni si Ja nga automatically protected by the law on copyright. So, mo ni silang mga example. For example, sa literary works and artistic works, kini silang mga gipangbutang dire. So, para masadyon hinumdumon kining bold, man, gas, papko, books, oral delivery, letters, dramatic, musical compositions, works of art, newspaper, geography, scientific or technical character, photographic works, audiovisual works, pictorial illustration, and computer programs. So, kung may nang ganitag literary works and artistic works, mao ni sila ang mga original works nga ang creator or ang author mao jud sila ang naghimo. Bali ilang kaugalingong skill, labor, and judgment without directly copying or evasively imitating the works of others. So, mato si Ja ang literary works and artistic works. So, next is derivative works. Like for example, dramatization, translation, adaptation, abridgment, arrangement, and other alteration of literary or artistic works. collections of literacy, scholarly, or artistic works, and compilation of data, o mao pa na diha ang mga example. So, kung may nga tag-derivative works from the root word derive, meaning nakahimo siya og laing works from the works of other. Bali na, for example, nakakita ka og painting ni sa imong kuan friend unja na-inspire ka, naghimo kag imong kaugalingong version ingana nga painting, pero dapat imong i-acknowledge ang author or naghimo ingatong first o asagikan tong imong gisundugan. Moto ang derivative works. The next is non-copyrightable works. Mo ni sila ang mga examples: idea, procedure, system, method, or operation, concept, principle, o kanang mga pang-list din ha. Mo na sila ang example sa non-copyrightable works. For example, sa non-copyrightable works, so naka-idea o unsaon paghimo og time machine. So karon gisuwat nimo ang imong idea unsaon paghimo og time machine. So katoy mo sinuwat, copyrighted na to. So karon nakabasa imong friend nga nagmaoy kay nagbuwag sila sa iyang uyab kay nakakitaglain. So gikan sa imong sinuwat na inspire ang imong friend nga maghimo jud og time machine. Actual nga time machine gajud. Naningkamot jud siya makahimo sa time machine kay arong makabalik ko no just panahon nga sila pa sa iyang uyab. So mao to nakahimo jud siya og actual. So karon nagpangutana kanang nabay copyright infringement na hitabo ingatong gibuhat sa iyang friend from sa iyang idea. Na may idea?
Again?
No.
Okay, the answer is no. Kay nga man, because kung nailaing tao nga nakahimo og actual nga butang from imong gikan sa imong sinuwat, there is no infringement because the application of a written idea is not a violation to the law on copyrights. Nasabtan ra ba? Hello? Ano sila? Okay, next na ta. Next is the rights of a copyright. Hello?
Ang sa katong giingon nga machine ba, the machine itself is patent to siya, not a copyright. Since copyright pertains to literary or musical pieces.
Yes, pero ang idea ra ni Jang nga sinuwat bali mahog sa letra katong ba iyang sinuwat ra nga idea ni Jang.
Okay. Not the
time machine itself.
Procedure to make the machine.
No. Ang idea ra mismo.
Okay. Thank you for the clarification.
Sige. So the next is the rights of copyright owner. So mao ni ang the presumption of authorship. The natural person whose name is indicated on a work in the usual manner as the author shall, in the absence or proof to the contrary, presume to be the author of the work. This is applicable even if the name is a pseudonym, where the pseudonym leaves no doubt as to identify of the author. So, pasabot na ay right ang author nasa jay right of ownership bisan pa og alias ra ang iyang gigamit. Nagyapon si jay right nga kopyahon or i-publish ang iyang hinimo kay ija man na. So ikaw ray mismo nga ay right nga kopyahon ba na nimo or ipapublish ba nimo ang imong hinimo. So next is the rights of an author. The first one is the economic rights. The right to carry out, authorize, or prevent the following acts: reproduction of the work or substantial portion thereof, carry out derivative works, first distribution of the original works, o so on. Manang nasa ubos ang mga list nga imong ma-prevent nga mahitabo. So bale sa economic rights, why bisan kinsa ang pwede mo kopya sa imong hinimo without your consent. Ikaw ra ang pwede og di ka mosugot wa. Kay ikaw ra pud pwede mo authorize og na kay right nga mo authorize og
you have the right to authorize somebody to use your work. Pero tahay, ang work is anonymous or nigamit ra kag alias, ang mo exercise sa kanang law, ang mo exercise sa right ang publisher. Kung tahay nakay sinuwat unja kanang anonymous siya, dyan na mo kopya. Ang mo execute sa right inga to nga book is ang nag-publish inga to nga book, for example. So the second one is the moral rights. For reason of professionalism and propriety, the author has the right to acquire that authorship of the works to be attributed to him, to make any alteration of his work prior to or withhold it from publication, right to preserve integrity of work, object to any distortion, mutilation, or other modification which would be prejudicial to his honor or reputation, and to restrain the use of his name with respect to any work not of his own creation or in distorted version of his work. So, ang pasabot, kintahay, magamit kay nga ng for example, imong gusto nimong himuong movie ang ijang libro nga hinimo, dapat mangadyo ka og approval sa writer inga to nga book kay magkagubot ta. So bale, kung dapat imo jong i-credits ang creator, kung kitahay mogamit kay nga ng linya ha, inga na dapat mogamit jud kang imo jong i-acknowledge kung kinsa ang creator or author inga na. So the next one is the right to proceed in subsequent transfer or follow-up rights. This is inalienable right of the author or his heirs to receive the extent of 5% of the gross proceeds of the sale or lease of a work of painting or sculpture of the original manuscript of a writer, song, or composer, subsequent to its first disposition by the author. The following works are not covered: prints, etchings, engravings, works of applied art, similar works wherein the author primarily derives gain from the proceeds of reproduction. So, bale, ang kini, pwede, since ma-assign ni mga copyright na kay sumusunod, makuha. Bale, ang imong mga anak, kung na kay hindi mong kanta, sila ang musunod sa profit, sa benefit, makasunod sila to the extent of 5% sa gross proceeds of sales or lease of work. For example, singer and writer imong tatay, unja namatay ang imong tatay, simbako, unja mo to, kung kitahay na ilaing mo gamit sa imong kanta, sa sinuwat sa imong tatay, bale kamo na ang mudawat sa benefits. Unja kung tahay pod na may naay kanta gigamit ang kinompose sa imong tatay, dapat kitahay ma-publish na. So daghan ng tao makagamit nga to kay na-publish naman. So di nimo makasuhan og copyright infringement ng tao kung hingamit ra sila inga na kay baliman na man tay gitawag nga fair use kana makagamit bisag kinsa basta laman ang kadto si di ni gamiton nga for profit na. Kung for example restaurant unja ang mga tao gusto ganahan ra mo anha sa imong restaurant tungod sa mga gipangkanta diha. So bali ang mga tao nianha ra tungod sa imong gigamit nga kanta unja wa kay pananghi dito mga anak nga gamiton ang kanta sa bali nagamit na to si Johnny mo nga nakadaganan siya na hinuon ka, so mo na di na pwede. Pero kung charity or fair use, okay rin si Johnny, di makagukod ang mga ears ina na. So ang mo discuss og sumpay sa rights of performers, producers of sound recordings and broadcasting organization will be discussed by Melchie Gohoko. Thank you.
So good evening again, everyone. I am the last speaker for tonight. and I will be discussing about the rights of performers, producers of sound recordings, and broadcasting organizations. So let's proceed. Producers of sound recording. The scope of right is subject to provisions of Section 212. Producers of sound recordings shall enjoy the following exclusive rights. First is the right to authorize the direct or indirect reproduction of their sound recordings in any manner or form, the placing of these reproductions in the market, and the right of rental or lending. The right to authorize the first public distribution of the original and copies of their sound recordings through sale or rental or other form of transferring ownership, and the right to authorize the commercial rental to the public of the original and copies of their sound recordings, even after distribution by them by or pursuant to authorization by the producer. So, communication to the public. If a sound recording published for commercial purposes or a reproduction of such sound recording is used directly for broadcasting or for other communication to the public, or is publicly performed with the intention of making and enhancing profit, a single equitable remuneration for the performer or performers and the producer of the sound recording shall be paid by the user to both the performers and the producer, who is, in the absence of any agreement, shall share equally. The limitation of right shall apply mutatis mutandis to the producer of sound recordings. So let's proceed to the broadcasting organizations. The scope of right is subject to provisions of Section 212. Broadcasting organizations shall enjoy the exclusive right to carry out, authorize, or prevent any of the following acts: the rebroadcasting of their broadcast, the recording in any manner, including the making of the films or the use of videotape, or their broadcast for the purpose of communication to the public of television broadcasts of the same, and the use of such records for fresh transmissions or for fresh recording. The limitation of rights from Section 203 to 208 and 209 shall not apply where the acts referred to in those sections are related to the use by a natural person exclusively for his own personal purposes, using short excerpts for reporting current events, used solely for the purpose of teaching or for scientific research, and fair use of the broadcast subject to the conditions under Section 185. The term of protection is subject to the provisions of subsection 213.2 to 213.5. The copyright in works under sections 172 and 173 shall be protected during the life of the author and for 50 years after his death. This rule also applies to posthumous works. The calculation of term is the term of protection subsequent to the death of the author provided in the preceding section shall run from the date of his death or of a publication, but such terms shall always be deemed to begin on the first day of January of the year following the event which gave rise to them. The term of protection for performers, producers, and broadcasting organizations. The rights granted to performers and producers of sound recordings under this law shall expire for the performances not incorporated in recordings 50 years from the end of the year in which the performance took place, and for sound or image and sound recordings and for performances incorporated therein 50 years from the end of the year in which the recording took place. So in case of broadcast, the term shall be 20 years from the date the broadcast took place. The extended term shall be applied only to old works with subsisting protection under the prior law. So, remedies for infringement. Any person infringing a right protected under the law shall be liable to an injunction restraining such infringement. The court may also order the defendant to desist from an infringement, among others, to prevent the entry into the channels of commerce of imported goods that involve an infringement immediately after customs clearance of such goods, and pay to the copyright proprietor of his assigns of hers such actual damages, including legal costs and other expenses, as he may have incurred due to the infringement, as well as the profits the infringer may have made due to such infringement. And in providing profits, the plaintiff shall be required to prove sales only, and the defendant shall be required to prove every element of cost which he claims, or in lieu of actual damages and profits. Such damages which to the court shall apply appear to be just and shall not be regarded as penalty. The criminal penalties. Any person infringing any right secured by provisions of Part 5 of this Act, or aiding or abetting such infringement, shall be guilty of crime punishable by imprisonment of 1 year to 3 years, plus a fine ranging from 50,000 pesos to 150,000 pesos for the first offense. So in determining the number of years of imprisonment and the amount of fine, the court shall consider the value of the infringing materials that the defendant has produced or manufactured, and the damage that the copyright owner has suffered by reason of infringement. So any person who at the time when copyright subsists in a work has in his possession an article which he knows or ought to know to be an infringing copy of the work for the purpose of selling, letting for hire, or by way of trade offering or exposing for sale or hired the article. The affidavit evidence in an action under this chapter is made before a notary public by or on behalf of the owner of the copyright in any work or other subject matter, and stating that at the time specified therein, copyright subsisted in the work or other subject matter, he or the person named therein is the owner of the copyright, and the copy of the work or other subject matter annexed thereto is a true copy thereof, shall be admitted in evidence in any proceedings for an offense under this chapter, and shall be prima facie proof of the matters therein stated until the contrary is proved, and the court before which such affidavit is produced shall assume that the affidavit was made by or on behalf of the owner of the copyright. The presumptions of authorship. The natural person whose name is indicated on a work in the usual manner as the author shall, in the absence of proof to the contrary, be presumed to be the author of the work. This provision shall be applicable even if the name is a pseudonym, where the pseudonym leaves no doubt as to the identity of the author. International registration of works is a statement concerning a work recorded in an international register in accordance with an international treaty to which the Philippines is or may become a party, shall be construed as true until the contrary is proved, except where the statement cannot be valid under this act or any other. Asa na to? Nawa ang copy.
Next.
Hindi na tanong. O, hindi na tayo.
Bukan yung
So, a statement concerning a work recorded in an international register in accordance with an international treaty to which the Philippines is or may become a party shall be construed as true until the contrary is proved, except where the statement cannot be valid under this act or any other law concerning intellectual property, where the statement is contradicted by another statement recorded in the international register. So the scope of application is the points of attachment for works under section 172 and 173. The protection afforded by this act to copyrightable works under sections 172 and 173 shall apply to works of authors who are nationals of or have their habitual residence in the Philippines. Audiovisual works, the producer of which has his headquarters or habitual residence in the Philippines. Works of architecture erected in the Philippines or other artistic works incorporated in a building or other structure located in the Philippines. Works first published in another country but also published in the Philippines within 30 days, irrespective of the nationality or residence of the authors. The provisions of this act shall also apply to works that are to be protected by virtue of and in accordance with any international convention or other international agreement to which the Philippines is a party. The points of attachment for performers. The provisions of this act on the protection of performers shall apply to performers who are nationals of the Philippines, who are not nationals of the Philippines but those performances take place in the Philippines or are incorporated in sound recordings that are protected under this act or which has not been fixed in sound recording but are carried by broadcast qualifying for protection under the act. Points of attachment for sound recordings. The provisions of this act on the protection of sound recordings shall apply to the sound recordings, the producers of which are nationals of the Philippines. You lost your connection. You lost your connection.
We're trying to reconnect.
No. You lost your connection.
Di we na ako.
Gimute. Wala na ako.
Ay, saan ako pa nag-data? Tanaw mo ba si Buwan na?
Saan na?
I-on na naman. Adyo na, agam ka na sa kansa.
Sorry na wa, guys. So, balik ta. Nalalap na. So, saan ko dapit? So, points of attachment for sound recordings. The provisions of this act on the protection of sound recordings shall apply to the producers of which are nationals of the Philippines and sound recordings that were first published in the Philippines. Points of attachment for broadcast. The provisions of this act on the protection of broadcast shall apply to broadcasting organizations, the headquarters of which are situated in the Philippines, and broadcasts transmitted from transmitters situated in the Philippines. The provisions of this act shall also apply to performers who and to producers of sound recordings and broadcasting organizations which are to be protected by virtue of and in accordance with any international convention or other international agreement to which the Philippines is a party. Institution of actions. Jurisdiction. Without prejudice to this provision of subsection 7.1, actions under this act shall be cognizable by the court with appropriate jurisdiction under existing law. Damages may be recovered under this act after 4 years from the time the cause of action arose. The Miscellaneous Provisions. The copyright section of National Library and the Supreme Court library shall be classified as a division upon the effect of this act. All copies and instruments deposited and instruments in writing filed with them will become the property of the government. The National Library Director is empowered to issue such safeguards and regulations as may be necessary to implement this and other provisions of this Act. Let's proceed to final provisions. So in all inter-parties proceedings in this Act, the equitable principles of laches, estoppel, and acquiescence, where applicable, may be considered and applied. Any conditions, restriction, limitation, diminution, penalty, or similar burden imposed by a foreign country on a Philippine national seeking protection of intellectual property rights in that country shall reciprocally be enforceable upon nationals of said country within Philippines jurisdiction unless restrained by a higher court. The judgment of the trial court shall be executory even pending appeal under such terms and conditions as the court may prescribe. The Bureau of Patents, Trademarks, and Technology Transfer under the Department of Trade and Industry is hereby abolished. All funds and fees, fines, royalties, and other charges collected for the calendar year, properties, equipment, and records are hereby transferred to the office. All applications for patent or trademark application pending at the effective date of this act shall be proceeded. Funding for the appropriation of this act shall be charged to the appropriations of the Bureau of Patents, Trademarks, and Technology Transfer under the current General Appropriations Act, and the fees, fines, royalties, and other charges collected by the Bureau for the calendar year. If any provisions of this act or the application of such provisions to any circumstances is held invalid, the remainder of the act shall not be affected thereby. So that's it for my report tonight. Thank you for listening.
Hello guys. Aray, hello. Asarang kuday. Hello. Napay tao.
Nantong iyon ang kuhan.
Ayo.
Hello, good evening.
Nakakita to.
Dali. Ihawa na nang slide. Ay, isa guys, kayong loading ang laptop. Hoy. Nasaan mo tayo?
Inita mo kasi laptop mo.
Buo na ron. Ihawa na.
Ikaw na lang ito, constrain record. Stop na lang parang pinag.
Ay, isa guys.
Ninghang. Ay, right.
First,
Di. Gisave mo.
So guys, kung kinsa tong fan og mga movies area, so advantage ninyo ang mga question na mong ihatag ninyo.
Ben, adyan na i-on ang camera.
I-on lang mo.
Kisa yung kaunag answer na ay 20 pesos na load.
Load.
Sige.
I-comment lang man din yung kaan.
Answers
Answer.
sa comment section.
Oh,
Dira.
comment section.
Message.
Okay. Wait ha. Isa.
Makitaan.
Di, wala pa man na naka-share screen siguro. Na-stop mo goro, be?
Wow.
Stop lagi.
Na-stop, uy.
Oh, nadya.
Ready na mo? Isa.
Pwede na.
Saan man ni?
Naman, hapon na sila.
Guys, ipanggutom na mo guys.
Panggutom na sila.
Number 1.
Saan man ni?
Kung ano naman yung open daan.
Medyo
Pwede mo open daan.
Ay, di. Gamay
Badyo
yun
man.
na to. Ba, grabe mo.
Kana mo na na dyan yung
Careful.
Okay, fire. Sige.
Kato kailangan. Ibaba na
Wait
ba?
ha. Asa to yung copy? Kung saan yung movie?
Hindi. Hindi.
Oh, sige. Ikaw. Isa. Hindi na kayo sure.
Guess the game. Clue.
Pagani ko.
Natay clue guys ha.
Sige.
Pagani.
1, 2,
Sige. Babay mo type ha.
pa man. Alam, gusto mo sa.
Babay mo type sa answer kay. Pero, ala oy, ngano man ni?
Di na naman.
Makita na day.
Asa ni?
So guys, if you can say na I message or na inform nga gisend sa message, mo na nga tong attendance
4 out.
Oh, for out. Oh. She, yeah, wait.
Ano yan?
Nakita na na. Tanaw.
Besa ni nga, duwa sa Squid Game. Duwa, bitaw nga sa duwa.
Nakita sa screen. Ano sa'yo nakita sa screen?
Kasi nakita
Ano
sa
sa'yo nakita sa screen?
Pa.
Wa pa?
Pahala na.
Hala, uy! Ay,
Kaya na naman ako na naman ba camera?
Wait.
O sige, katuro dahil i-on.
Oo.
Ha, i-stop.
Para din ang tabalangan kay ibang
Ah,
na
sige,
sila,
sige.
promise.
I-off na ato.
Oh, sige.
Be, asa tong imo. Pag i-half o i-half.
Nara.
So guys, ready?
Okay.
Unsa ni si Jia nga duwa sa
Sa Squid Game.
iya.
Okay, type your answer. 3,
Type your answers,
2,
guys.
1.
Go.
Okay, nakauna si Daniela Shane Montabon. Red light, green light.
Sige,
Number
number
please.
Number please.
Wait, i-mute niya. Isa. Tingnan.
Okay.
Okay, next. I-off sa game camera. Then,
Next.
Dara, the number.
Oh, na number.
screenshot
number.
dai. Thank you. Next is...
Next.
Ay, sa dai. Kaya sa screenshot tag number. Next is... Ge. Becky sini. Who is
Ayun,
in the
umaga.
picture?
Barbie Dalati.
1, 2, 3. Sige,
Type your
pwede na
answer.
i-type. Ang answer. Kisa kayo makanswering nga ni.
O sila
O sila kaabot.
Ang
Mga
fra-
episode.
Clue, nasa One Piece nga character na kontra ni Luffy.
Wala sila kaila.
Dalawa kaila.
Ako na load. Dalawa sila kailaw.
Why low dira? Nag-off ni dire?
Oo.
Ang nagnabuing. Hello, kinsay nakailaan eh. Pwede na mo type sa inyong answer. Halaway mo tanaw og kuan dire, One Piece. Halaway ganahan og anime ang mga naning. Sige ragtoon. Sana all.
May nanubag.
Guys, napa mo? Line picture ta.
Okay, laing
Line
picture.
picture.
Sige, next picture.
Balikon na to. Huna-huna sa mo kinsana. Hani, grabe gwapod mo kaila ni oy.
Isa. Wow.
Sige.
Pakita na yun.
3, 2, 1. Type your answer.
Type your answer. 1, 2, 3. Kinsa na? Clue na asa
Nanas
Harry Potter nga movie series. Hala, may tingog. Ay, window. Ito na naman screen. Entire screen.
Okay, sa.
Hello. Hala, nawa dahil itong tingog. Nang sa tuyor.
Kinsa ni?
Type your answer.
Type your answer. Oh, pwede. Dumbledore.
Wow,
Okay.
sige, Dumbledore. Palihog ko sa imong number.
Maui.
Maui Martin
Maui
Beronio.
Martin Beronio. Number please.
Wow.
Sana
Active
all.
ba?
Next. Pabalik to ko ano sa.
Anjali.
Narab jud day ko kanang iingon ra. Kana ikilid ra oh. Kana.
Nice. Kinsa ni?
Kinsa ni? Nasa One Piece.
Iso dito.
Lawa na kaila mga naning mga naning ka jud ay ag pagkita kay pamatay.
Bene na ba yung answer? Oh,
Katakuri.
Katakuri.
Wasa na.
Reggie Sandoval.
Number please.
Type your
20
number.
atong load guys ha, 20 kay mga estudyante patapo
Four.
na ng 1,000. Number please,
Okay.
Sandoval na.
Na. Okay, proceed ta
Sa
ika-upat. Humanamay
Upat.
no si Dumbledore.
yes.
Kani.
Kani, unsa ni nga title sa movie series?
Type your answer now.
Type your answer now.
Game of Thrones.
Janet.
Janet Lagusad.
No, Janet Lagusad.
Janet Lagusad. Palihog ko si mong number. Si Janet Lagusad. Game of Thrones.
Ano na number?
Isa. Picture ta. Sunod. Sunod, madam. Last.
Last na ni, last. Andam.
Teng, teng, teng.
Oh.
Korean.
Korean ni si Janga series.
Sana all. Heartbreaking.
Heartbreaking kaayo. Unsa ni? Complete.
Complete nga answer.
Complete nga answer.
Nana, si... Ang taga... Scarlet Heart. Rio. Sakita ka, Jod. Sige na. Kana si... Jana Grace.
No.
Rio man.
Ah, okay.
Scarlet Heart Rio.
Jana
Grace Abrantes.
Type your digits. Unsa na?
Number, please. Abrantes. Number.
request nga ipa-on ilang
Or i-on ang camera. Ay, magkuha na dahil ko. F9.